an offensive or false material may have been published online, criminal liability under Section 22 only attaches to the actual publisher. In this case, the prosecution failed to bridge the evidentiary gap between the existence of the publication and the responsibility of the accused person. On the second issue, even if the court was to accept the prosecution evidence against the accused person from the evidence of the accused and the submissions by the defense and the Law Society of Kenya, the accused person's gadgets were seized and examined forensically without any court order. Indeed, the investigating officer in his evidence considered the same. Even the witness from Safaricom, who was PW5, considered he had extracted the accused person's personal data and shared with the DCI officers without any formal court order. On cross-examination, the IO tried to sanitize the process by claiming that he had later gone to court and filed a miscellaneous application on the 16th of November 2024 and obtained orders on the 18th of November 2024. It should, however, be noted that the said miscellaneous application and orders were never produced in court. Be as it may, even if the court was to indeed assume that the IO had gotten orders on the 18th of November 2024, this was way after the illegal search and seizure of the accused person's electronic gadgets. Under Article 31 of the Constitution, it guarantees every person the right to privacy, including the right not to have their person, home or property searched or their possessions seized except in accordance with the law. Under Article 50, subsection 4 of the Constitution, it provides that evidence obtained in any manner that violates any right or fundamental freedom shall be excluded if the admission of that evidence will render the trial unfair or otherwise be detrimental to the administration of justice. In the case of Ismail Mwana Otieno versus Republic, the court observed that evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of that evidence will render the trial unfair or will otherwise be detrimental to the administration of justice. Similarly, in the case of Okia Omutata versus Communication Authority of Kenya and 8 others, the High Court emphasized on the intrusion into digital data and stated that it must be strictly comply with the constitutional safeguards. Further, under Section 118 of the Criminal Procedure Code, it requires investigators to obtain a search warrant before searching the premises or seizing property unless under exceptional circumstances. Electronic devices such as mobile phones and computers contain extensive personal data and attract heightened constitutional protection. In this case, not only were the accused person's gadgets seized unlawfully, they were subjected to forensic examination without any judicial authorization. I do believe the forensic extraction constitutes a separate and more intrusive breach. In the case of Republic versus Mohammed Bashir Mohammed and another, the court held that digital forensic analysis requires judicial authorization.
And the defense team of the lawyers that are present before this court, that is Stanley Kinyanjui, Tina Swiga, myself, and Shabra Pamboi was the background. We also wish to thank the state, the DPP, for prosecuting a matter that was brought that had no legs to them. But they have done a good job. And want to thank the court, that the court has stood with the constitutional safeguards. And the court has stood, has looked at this young man and given him a lease of life. The young man can proceed with his studies, and the young man can trust that there is the judiciary that is independent, that decides cases without fear of failure. This is a landmark decision, as we had said. It was the only matter out of the demonstrations that has gone to judgment. All the others were withdrawn, and we thank the court that the court has rendered a reasoned judgment. It is only unfortunate that it is not a court of high status, because this serves as a roadmap for the DCI and the investigative officers to follow the procedures when a matter cybercrime is mentioned. We are not condoning the offense of people misusing their phones, but the state has a duty to follow the statutory and constitutional roadmaps that have been presented before, or else the state might never convict anybody, those especially who have committed serious offenses. You know, that's all. I am the only lady seated here. She's telling me that her voice can tone me down. Allow her to say what I want.
Yes, Your Honor, we want to take this opportunity to thank the court for the reasonable judgment. And we want this to serve as an example for those who have been mandated with law enforcement and discharging their mandates, that they should follow what has been prescribed in the Constitution without fear or favor of any person, and that the ordinary mwananchi, the ordinary Kenyans, will not be subjected to unfair treatment in the criminal justice system, and that the criminal justice system will not be used as a ploy to show who is stronger than the other. Your Honor, we are grateful for your judgment. Thanks.